In this video, we will discuss as regarding question number 10, what do you mean by excessive delegation? Does the court disapprove the practice of excessive delegation? Then question 11 discuss the parliamentary control over delegated legislation. Question number 12 discuss the doctrine of ultra-virus as judicial control over delegated legislation. And question number 13 define the powers which cannot be delegated by the legislative to the executive. So, in reference to question number 10 regarding excessive delegation, it has been settled in Delhi Laws Act case 1951 by the Supreme Court by majority decision, and a number of cases still then that there is a limit beyond which delegation may not go. The limit is that essential legislative power of the legislation cannot be delegated. If the legislative delegates the essential legislative functions, it is in excess of what it should do. So, in relation to that, the Supreme Court declared Section 2, Para C of State Laws Act 1950, which provided that the provisions may be made in any law or enactment so extended for the repeal or amendment of any corresponding law which is for the time being applicable to that part C state as ultra-virus, because the law to repeal or abrogate existing law is an essential legislative function which cannot be delegated to the executive as it is deemed as excessive delegation. So also in the leading case, Hamdar Dabakhana versus Union of India in 1960, Supreme Court held Section 3, subsection D of Drugs and Magic Remedies Objectionable Advertisements Act 1954 as any other to include as any other disease or condition which may be specified as the rules under this act was held by the court to have delegated unrealized powers in the hands of the executive and therefore constituted excessive delegation. So also the liberal judicial attitude is justified by the court in state of Tamil Nadu versus MS Hind Stores in 1981. The Supreme Court has held down that any statute which provides unguided power of legislation to the executive shall be met with disapproval by the court. The practice of executive delegation would otherwise turn democracy into despotism. So also in the case of P.K. Trivedi and Sons versus State of Gujarat in 1986, the Supreme Court again dealt with the question of excessive delegated legislation. It was held that the contention that Section 15 of Mine and Mineral Regulation and Development Act 1957 is tainted with excessive delegation, as no guidelines is provided to the state for exercise of power is not correct. So Supreme Court held that Section 13 of the Act provides directives for formulation of regulation. It also added that when any part of the disputed act contains regulation for the formulation of rules, etc., the shortcomings of excessive delegation goes by itself, and the authorities concerned are deemed to frame rules in accordance with that section which provides for the regulation of power. And as regarding the question number 11, as relating to parliamentary control over delegated legislation, so in that sense the parliament exercise controls in two different categories such as direct general control and direct special control. So under direct general control over the delegated legislation, one is the requirement is thorough debate on the act which contains delegation, and secondly thorough questions and notice on the very act which contains delegation. So also the thorough moving resolutions and notices in the House, and the fourth one through vote on grant, and the fifth one through a private member's bill seeking modification in the parent act, or through a debate at the time of discussion on the address by the President to the joint session of Parliament. Members may discuss delegation. So also under direct special control mechanism over delegated legislation of the Parliament or such laying with no further direction. So in this type of laying, the rules and regulation come into effect as soon as they are laid. It is simply to inform the House about the rules and regulation, and secondly, laying subject to annulment or laying subject to negative resolution. In this process, the rules come into effect as soon as they are placed on the table of the House, but shall cease to have effect if annulled by a resolution of the House. So laying subject to affirmative resolution, the technique may take into two shapes. One is that the rule shall have no effect or force unless approved by a resolution of each House of Parliament, and secondly, that the rule shall cease to have effect unless approved by an affirmative resolution. So also laying in draft subject to negative resolution, such a provision provides that when any act contains provisions for this type of laying, the draft rules shall be placed on the table of the House and shall come into force after 40 days from the date of laying unless disapproved before that period. And lastly, laying in draft subject to an affirmative resolution. In this type of laying, the instrument or draft rules shall have no effect unless approved by the House. So the very question relating to question number 12, and that is relating to doctrine of ultra vires, and so in that connection we'll discuss the very different types of control as under doctrine of ultra vires. and that is one is procedural ultravirus and the second one is substantive ultravirus, and it is a judicial control of delegated legislation. So regarding procedural ultravirus, every administration may be required by the enabling statute to consult with particular bodies before making subordinate legislation. It may also be required to publish draft proposals and to hear objections, make representations. These are procedural requirements which may be made necessary before enforcing any subordinate legislation. So, a failure to consult particular bodies, publish or hear will invalidate any document subsequently made. Thus, any regulation, order, etc., made in contravention of mandatory procedural requirements would be invalidated by the courts as being ultra vires the enabling statute. And as regarding substantive ultra vires, the court will offset subordinate legislation unlike an act of the parliament where it contains provisions not authorized by the statute or where it has exceeded the limit laid down in the parent or enabling statute. The administrative authorities are required to act within the limits laid down in the statute. It is the duty of the court to constitute the statute and find out whether the powers have been exercised properly. The words used in the statute determine the extent and limits of delegated authority. The use of general terms in the statute gives greater scope of exercise of the powers to the administrative bodies, and therefore the court's control is less effective. But where the definite and precise words are used, not giving rise to duality of meanings, their control over delegated legislation is more effective. Where the power to legislate is widely phrased, there is hardly any scope to turn down the rule or regulations made thereunder. So, in certain circumstances, doctrine of ultravirus is also ineffective. As such, where the object or purpose of the enabling statute is so widely worded that almost everything is covered by it. And secondly, the ministers are often empowered to make such regulation as appear to them to be necessary or expedient for a specific purpose, or the distinction between administrative and judicial legislative acts is very difficult to be done. So, now we will discuss the question relating to the powers which cannot be delegated by the legislative to executive. So, such powers are the penal laws, and such penal laws as such, no act or activity should be declared as offense and made punishable by a rule or regulation made under the delegated authority. And also the retrospective operation. The rule should not be given retrospective operation. Giving a rule any retrospective prospective effect is essentially a legislative act. In any case, no rules should operate from any date anterior to the date of the commencement of the enabling act, and thirdly, exclusion of jurisdiction of courts. The subject matter of jurisdiction of the courts and the administration of justice are purely legislative acts in character, and administrative bodies should not be given power to effect any alteration in the jurisdiction of any court of law by declaring that the court shall not take up any particular category of cases, or the jurisdiction of any court shall be barred in particular type of cases. And the fourth one, monetary and financial matter. The monetary and financial matters should be dealt by the lower house of the legislature. It is desirable in the interest of public that such matters are dealt with by the house itself, even when such power is given to the executive authority on special grounds. The rule should not operate before it is approved by the affirmative procedure of the legislature. And the fifth one, that is regarding compensation. And as under Article 31, Clause 2 of the Constitution of India, the principle on which the compensation is to be determined and the manner in which the compensation is to be determined in respect of any property compulsorily acquired or requisitioned for a public purpose, since such determination is an essential legislative function. So also the sixth one, that is regarding taxation. So under Article 265 of the Constitution, no tax shall be levied or collected save by the authority of law. So the very expression law therein does not include the statutory rules. Therefore, no tax should be levied or enhanced by means of rules. But when delegation becomes inevitable, the power should be never unlimited, and specific conditions for its exercise and things to be taxed, the range of rates, etc., should be clearly laid down. And lastly, the legislative cannot delegate its essential legislative functions in any case, as it was decided in the leading case Farm Mystery Arabji Bhai Sanjeev Bhai versus State of Gujarat in 1967 by the Gujarat High Court. So these are the powers, and under what conditions cannot be delegated by the legislative to the executive, as we have decided. So also how the doctrine of ultra-virus would be ineffective under what conditions, and the very parliamentary control of delegated legislation and all the meaning of excessive delegation and how it was determined and decided by the apex court regarding the very excessive delegation, as it is not provided under the parent or enabling act. So in that connection, just now we have finished these four questions, and the relevant leading cases as decided by our apex court or Supreme Court or by certain high courts.